Hi, it's Roland Jones. This is another short video on preference and fraudulent conveyance issues. In this video, I'm going to take a quick look at another defense that comes up when there's a preference case brought by a trustee, and the defendant is in the agricultural industry. In this case, we're going to talk about PASA. In the last video, we talked about PACA. The case is Right Way Meat Packers. It's a Delaware case, 2009. In this case, the defendant was in the business of providing processed meat to the debtor, who marketed pre-cut meat, poultry, and pork products to manufacturers. The vendor supplied the meat to the debtor. Debtor goes bankrupt. Trustee is appointed. Trustee sues the vendor of the meat, since the vendor was paid within 90 days of the bankruptcy, prior to the bankruptcy filing, and the vendor does what? He looks to PASA to protect them. The supplier argued that pursuant to the Packers and Stockyards Act of 1921, also known as PASA, the identified payments, the payments that he received, were not property of the estate because they were held in trust for the defendant. So the question is, did it fall under PASA or not? Were these funds and the meat itself all protected by a statutory trust created by PASA, which took them out of the property of the estate, and therefore out of the hands of the trustee to avoid a preference action? The applicable code section is 547B, and this section that I highlighted, is it a transfer of an interest to the debtor in property? Does it belong to the debtor, or is it not, because the funds are in a trust? The opinion quoted this section, and I basically took a picture of it and stuck it here, and it sets forth the elements that a vendor must meet to come under PASA. PASA requires that packers who purchase livestock on a cash basis hold such livestock, including meat and other products, and account receivable proceeds derived therefrom, in trust for the unpaid cash sellers. So, number one, commodities sold are livestock, as that's defined in the statute. Two, the purchaser of the livestock is a packer, as that's defined. Three, the transaction is a cash sale. Four, the cash sellers have not received full payment for their livestock. Five, the packer in question makes annual purchases of more than $500,000. And six, the cash sellers have preserved the trust within the required period by giving notice to the packer and by filing that notice with the Secretary of Agriculture. So there's a lot of elements here that must be met, similar to PACA. Additionally, one last element, the sale must take place in the interstate commerce. That's probably the easiest one. In this case, this was a motion to dismiss by the meat vendor. In other words, there was a complaint filed, and instead of filing an answer, the vendor's lawyer filed a motion to dismiss the case. The court basically said that a motion to dismiss was not appropriate because it didn't know any of the facts. The court couldn't tell whether these were cash sales as defined by PASA, and there wasn't an indication either by the defendant or the plaintiff whether the PASA notice requirements were fulfilled. So for that reason, it denied the defendant's motion to dismiss. And that's basically the extent of this opinion. I did a slideshow on the opinion. just to show when PASA can come up in the context of defending a preference case and the elements that have to be shown for the defense to work. In this case, the judge is saying he's got to take a closer look at the facts to see whether those elements were satisfied or not. But if you're in the position of this defendant, then these elements need to be satisfied in full, or the defense simply won't work.